Okay, good afternoon, everyone. This is Judge Lopez. Today is June the 9th. I'm going to call the status conference in Diamond Sports. The parties who wish to, I'm going to ask everyone if you need to make an appearance. I just ask that you go to the website and make an appearance. Hop on the Southern District of Texas website, find my page, find where you can make electronic appearances in complex cases, find this case. For the parties who wish to speak today, I'm going to ask that you hit *5, and I'm going to unmute your line. Only if you intend to speak today, and then you can hit *5. And I'm going to unmute a few lines, so I'm just going to ask that you please just place your phone on mute. I'm going to start with, obviously, debtors counsel, and then we'll just work our way around. Alrighty, I'm just going to unmute a number of lines. Anyone else? Just anyone who makes an appearance, not just debtors, anyone else who is going to speak today, either from MLB or any other teams. Why don't you go ahead and hit *5. Okay, is there someone from the debtors whose line is unmuted? And I want to make sure I've got you. I've been hearing something about a *1 as well, and if *5 isn't working for you, try *1. I don't know. I'll look into that.
Your Honor, I think it's 5-star.
Yeah, it is 5-star. Did I say *5? 5-star. I've been getting multiple reports on stuff. Let's go.
Your Honor, this is Andy Goldman from WilmerHale on the 917-626 number.
You got it. I can hear you.
Right.
I got you.
Right. And with me is my partner, Ross Furstenbaum, who will be presenting this afternoon.
Okay, Mr. Furstenbaum, good afternoon. Make sure I've got someone from the committee unmuted as well. Is there someone?
Your Honor, can you hear me? This is Marty Brimmy.
Mr. Burimich, I can hear you just fine. Is there anyone?
Good afternoon, Your
Honor. Alrighty. Someone from MLB on the line, unmuted?
Hey, Your Honor, this is Jim Bromley. Can you hear me?
Just fine. Good afternoon, Mr. Bromley. Anyone from the Rangers? Anyone from the Rangers on? Unmuted.
Yeah, good afternoon, Your Honor. Glenn Kurtz from White and Case on behalf of the Rangers. Can you hear me?
Just fine, Mr. Kurtz. Good afternoon.
Thank you.
Is there someone from the Guardians on the line?
Good afternoon, Your Honor. It's Oliver Zeltner, Jones Day, on behalf of the Cleveland Guardians.
Okay, good afternoon. Someone from the Diamondbacks on? And if you can, just hit *5. Anyone from the Twins on? Just checking. Hold on, I've got one more line. I just unmuted one more line. Let's see. Okay, I think we can get started. I will do another check on the 5-star. Mr. Furstenbaum, why don't I turn it over to you? Mr. Furstenbaum?
I think you need to 5-star.
Mr. Furstenbaum, can you hit 5-star? You may have, there you are.
Thank you, Your Honor. Can you hear me now?
Just fine. Good afternoon.
Excellent. Good afternoon, Your Honor. For the record, Ross Furstenbaum from WilmerHale, and I'll be speaking today on behalf of the debtors. We're here for a status conference regarding the debtors' emergency motion for clarification of order granting motions regarding telecast rights agreement at ECF 838. The proposed order that we are asking the court to enter is at ECF 849, which the debtors just filed in the last half hour to fix a computational error that was in the prior proposed order. Your Honor, the debtors have 4 payments due under these agreements over the next 21 days, including one as early as next Thursday, June 15th. Which is a very large payment. I won't mention the specific number for confidentiality reasons, but I think everybody would agree that it's quite large and it's due to the Rangers. Because of these upcoming payments, the debtors seek on an emergency basis clarification of the court's June 2nd order to ensure that the Rangers and the other 3 clubs do not receive a windfall should the debtors reject any of the contracts and stop televising games after these payments are made. The debtors believe this is a straightforward clarification, application of the court's June 1st ruling, of prior case law, of the bankruptcy code, and is consistent with the court's cash collateral order and the telecast rights agreements themselves, and also consistent with fundamental fairness and efficiency. Now, as the court knows, we didn't see the June 2nd order in advance, and we also aren't able to ask questions at the end of last week's hearing. We certainly appreciate that we were well into the evening and it had been a long 2 days. But after seeing the order issued by the court, we and our creditors had concerns that the order could be interpreted, although incorrectly, we presume, to require the debtors to make payment in full without being entitled to any refund for any overpayment that may be made. And so for these reasons, which I'll explain more fully, the debtors would respectfully request that the court enter the proposed modified order at ECF 849, the modification being the addition of paragraph 4 to the original June 2nd order, and the additional paragraph effectively providing that if the debtors reject one of these agreements or if a club otherwise terminates one of the agreements and the debtors stop using the rights in such agreement, that the club should return to the debtors the pro rata share of the payments made for games that were not delivered after the rejection or termination of the agreement. So the provisions of the order, I'm sure the court is well familiar with it, but the court obviously held that the 4 teams are granted administrative expense claims for all outstanding post-petition amounts that the debtors are obligated to pay under the agreements, and that unless otherwise ordered by the court, the debtor shall pay the clubs any future amounts due in accordance with the terms of the agreements. We and our creditors are concerned that Major League Baseball and the clubs might rely on this language to suggest that we must make the payment and have no right to a refund if we reject and after having made the payment. And, you know, this isn't hypothetical. I think the commissioner was very clear about Major League Baseball's feelings toward the debtors last week, and we and our creditors are concerned that Major League Baseball's strategy is to run up costs.
Let me do
and
this.
We don't think
Mr. Furstenbaum, let me do this, because I think this is going to quickly head towards then the MLB and the Rangers defending themselves, and so I don't want to kind of rehash issues or testimony that was laid out in the prior hearings. My ruling is on the record, and it says what it says, and there's a transcript available and an audio there. So let me say this, and I'm going to turn it over to the MLB and the other teams as well, and I'm going to let you finish. But you know, what was asked of me at that hearing in connection with the motions was a motion to compel performance. Right? That was the request to compel performance because games are being played, and there was a cash collateral order that was requiring, at the time, 75% payment plus a 25% holdback, right? And the court ruled on that issue. The concept of, and I also said, well, the contract rate is going to be the rate, so we're going to take out essentially the holdback, pay them the 25%, and if amounts are due, then you got to pay it. We're going to follow the contract while pending assumption or rejection. I didn't compel the debtor to assume or reject by a certain date. So really that's what the order says, and no one should read more into it, right? I think the concept of assumption brings certain facts along with it. I think the concept of rejection, if there's a motion filed, brings along a host of issues and, potential reconciliation issues one way or the other. But in terms of adding something to the order, upon a matter that was never that wasn't part of the team's motion, I'm not comfortable doing it. I never thought about adding it to there because it wasn't mentioned. And even if someone would have asked me about it at the hearing, I wouldn't have answered the question because I don't know. We don't know what we don't know until we get there. And I didn't know if anybody was going to, and the debtors were going to file a motion to reject. But if there is one filed, then I think we're going to have to take up a host of issues at that time because it's just the nature of what happens. And so the concept of an administrative claim is, it's actual and necessary. So I think the concept of windfall or underpayment are, both off the table. I think. But I don't want to get into calculating what that number would be, what a proper calculation under the contract would be. I think that's premature, and we don't know what we don't know. And I don't know the timing or even if one's going to get filed. And so it does feel advisory to me. But I understand the concern. I think it's a bridge we're going to have to cross if we get there. And that's the most I'm comfortable saying at this time because I've got to really stick to the relief requested before me and what I was asked to rule on. And to add a sentence without giving everyone due process, I think the process would demand that I give everyone a full and fair opportunity to weigh in on the issue. And it wasn't brought before me. So I think that's the most that I'm comfortable saying. And I don't want discussions that are happening outside of the courtroom to find its way inside this hearing. And I got it. There are positions that are being taken, and that's fine. I don't know what they are, and quite frankly, I think it's probably best until I think I only step in when motions are filed and relief is requested of the court. I think that's when the court has to step in. But I don't know if that's why I call it a status conference rather than kind of a full-out motion, hearing on the motion. I think that's what I'm comfortable saying. I'm not sure I'm comfortable saying more because I don't want to step in and talk about things that were not before me at that hearing. I think just trying to be as honest and transparent with everyone as possible. But I think obviously there's going to be a host of issues that come if you file a motion to reject one or more agreements, and we're going to have to take those issues up at that time.
Thank you, Your Honor. I appreciate the court's comments and understand loud and clear that the court's not going to issue any further order providing a mathematical formula. However, if I could ask Your Honor to entertain amending the order at least to the extent that it makes clear that it is not intended to waive any rights that the debtors would have, for example, under Section 502J, which clearly would contemplate the debtors recovering any overpayment that is made without getting into how much that overpayment would be or how it would be calculated, just to make clear that the court was not intending to, and I don't think anybody would have interpreted the court to have been issuing a ruling that would take away the debtor's rights under 502J to recover an overpayment in the event that there's a rejection after a payment is made.
Okay, let me open it up and hear from other parties. Mr. Bromley, why don't I start with you, and then I can.
Yeah.
Let me just hear from Aaron, because I'll give you some thoughts. But let me open it up to MLB, and then maybe I'll turn to Mr. Kurtz, and then turn it over to the see if there's any other team that wishes to speak. Mr. Bromley, I'm not requiring you to speak. I'm just giving you an opportunity if you wish to.
Thank you very much, Your Honor, and I apologize for any background noise that you may hear. We don't have anything to add to our papers which we filed, and I think that in terms of counsel for the debtor's request, second request, in effect the one that was just made, I think everyone's rights are what they are. If the debtors decide to file a motion to reject any of the rights agreements, then they will have whatever rights they have. We're not looking at the order that Your Honor entered last week as definitively making any decisions with respect to motions to reject that have not been filed. Hopefully that from an MLB perspective, that clarifies our position.
Thank you. Mr. Kurtz?
Thank you, Your Honor. I think I probably have a pretty similar response here. We haven't actually had discussions. Your Honor indicated maybe there were things going on behind the scenes that prompted. There actually hasn't been any discussions. I'm not sure what the circumstances are ultimately going to be and what impact that Your Honor's order would have on it. So I think we're sort of in the position where it seems to be advisory. We seem to be trying to figure out something based on a set of facts that don't exist. And so I think Your Honor's order was pretty comprehensive. I think it's pretty unambiguous, and I'm not sure there's a need to amend it in any way.
Thank you. Let's see. Any other team wish to be heard?
Your Honor, it's Oliver Zeltner on behalf of the Guardians.
Yes, sir.
We have nothing to add. We have nothing to add beyond what Mr. Bromley and Mr. Kurtz said and beyond what's in the objection.
Thank you. Anyone else?
Your Honor, I do believe that Mr. Eggerman from Kramer Levin for the lenders wanted to be heard.
Let's see. Mr. Eggerman, can you hit 5-star? Unless I've already unmuted you, John.
I think you've already unmuted me.
Got it. I can hear you. Can hear you just fine.
Thank you. Daniel Eggerman from Kramer Levin on behalf of the ad hoc group of First Lien lenders. Obviously, this is an important issue to us because it's our cash collateral that's being used to fund these payments. So Mr. Furstenbaum was correct that this is something that is very close to near and dear to the creditors, the secured creditors' interests here. I have a whole presentation to make. I'm not going to make it because I got the direction from Your Honor. I know where you're going. But the key for us is just to make sure that nothing in the order precludes us. We think there's rights under 502J to reconsider and disgorge. Personally, I thought the debtors' structure made sense to have them disgorge and then file any admin claims that they have. Your Honor doesn't want to go there. I respect that. I understand it. But I think, as Mr. Furstenbaum followed up, I think it's important to make it clear that the order isn't waiving anyone's rights. Everyone's rights to argue that there is an overpayment are preserved. The team's rights to argue that for some reason there was no overpayment, those are preserved. Fine. I just didn't want this order to be used in a way that it wasn't intended. And I don't think Your Honor intended this order to preclude arguments. I mean, for example, some of these teams are going to be basically paid in full for this entire season in 3 weeks. And it wasn't that issue, and I didn't want this order to somehow foreclose reopening arguments on undisclosed.
Understood. Let me ask Mr. Brimage, is there anything, I'm just going around, I want to make sure that the committee if you wish to say anything.
Thank you, Your Honor. Marty Brimage with Aiken here on behalf of the committee. I'll be brief because it's really already been said. I mean, and you've reiterated that you're not going to compel the debtors to be on a clock for assumption or rejection decisions, and that was something that was important to us, and you ruled that way. I think at this point, we just want to make sure that all parties simply have the rights that they normally would have under a rejection scenario, and that the order doesn't in any way alter those rights, which I think I hear you saying it does not. And so if and when that situation ever arises, we can have, you know, the normal rejection process play out. And we just want to make sure that the order, and I think your clarifying comments have been helpful, don't in any way infringe on anybody's rights to have that hearing in the way that they normally would. And with that, Your Honor, I have nothing further unless the court has any questions.
No questions. Mr. Furstenbaum, I believe I did not allow you to finish certain statements, and I apologize.
No, Your Honor. I think you did. Like Mr. Eggerman, I had a complete presentation, but I understand the direction Your Honor is headed in, and just want to sort of reiterate the final point that I made, which is that I think, you know, we and the creditors would appreciate just some clarification in the order that no rights have been waived or changed from the court's order, including the rights to recover an overpayment under 502J.
No, I'm not going to change the order. The order stands what it says, but the order followed a ruling on a motion to compel performance and to, that's what I ruled on. And issues of rejection and arguments to other parties that people can make, like none of that it's not even contemplated under the order, right? It's the order is granting a motion that was to compel performance under the contract, and what effect a motion to reject, assume or reject has on that are issues for another day. So I think the teams have whatever rights they have. I think the MLB has whatever rights it has. The committee has whatever rights it has, and the debtors have whatever rights they have. Everybody's going to get a chance to, you know, I don't know whatever you're going to file, but whenever you file it, you can argue what you want. And I don't think that's any surprise. I ruled on a motion to compel. And I think parties can make arguments, but the court has made a ruling, put it into the record, and there's an order that reflects that ruling. And that's the most that I'll say. I don't think any of this is coming as a surprise to anyone. What I don't want to do is start adding things into an order, a calculation or additional things that were not part of the relief requested, because courts, I'm issuing an order based on a specific relief that was requested in a motion. Yeah, I'll give you that much. I hope that helps.
Your Honor, thank you very much.
All righty. So I'm gonna. It's okay. It's okay with the parties. I'm just gonna. I don't want to take up the motion or deem it moot. I just think I'm just going to deem the motion moot for the reasons that I've stated on the record, and leave it there. I don't know what happens, but if motions get filed, I'll consider them. And there was a specific motion that sought relief requested, and I, made a ruling based on the specific relief requested. And there were specific requests in there, and that's what the court ruled on and nothing more. I think that's what everyone should consider. Everybody's rights are preserved. That's really what I'm saying. Your Honor, understood. Just everybody's rights are preserved. There's a motion to reject. You have whatever rights to argue whatever you want, just like you normally would. I don't think I took anything up more than, what to do with compelling. I think I probably would have said that at the hearing, after the hearing, and I'm comfortable saying it now. But really, that's about the bounds of where I'll go. All righty.
Thank you, Your Honor. We appreciate that clarification. I think that's very helpful, and we're happy to proceed that way.
All righty, folks. Thank you very much. You'll have a good weekend. Thank you.
Thank you.
Thank you. You too.